Gentleman yields back. The gentleman from California withdraws his point of order. The gentleman from North Dakota is recognized.
Thank you, Mr. Chairman. I move to speak in opposition to the amendment. They don't get to choose. They don't get to choose. We spend a lot of time in this hearing, in this room, talking about, I've been an advocate for recording interviews, recording arrests, doing all of this. There's a pretty known legal precedent and legal rule of the best evidence rule, and it exists everywhere. The person providing the evidence doesn't get to choose the manner and form in which the evidence is provided. And this also happens to be a pattern. 5 minutes before the Hur hearing, we got the transcript. 5 minutes before this hearing, we get the invocation of executive privilege. There's a difference between a transcript and a video and audio. And I don't possibly understand the argument of, we'll release the transcript, but we won't release the tapes, and that's going to determine whether or not somebody participates in an investigation, which, by the way, that can be compelled to be done as well. The argument that this is somehow anything other than the DOJ trying to pick and choose which pieces of evidence or which parts of evidence are what they determine is the best evidence to our committee is just, quite frankly, not based in any precedent with under law. I spent 10 years doing this. I spent 10 years doing discovery requests. I never asked for permission. I'm entitled to what it is. They don't get to determine what we get. That is not how the system works. And it can't be how the system works. Because otherwise, the people who you are trying to conduct oversight on determine what information you get to conduct that oversight. That is just simply not how the separation of powers is set up. It's not set up in how any legal investigation in any jurisdiction in any form exists anywhere in the country. The audio tape exists. That is the best evidence in which to conduct oversight, and this committee is entitled to it. And with that, I yield back.
Gentleman yields back. Who seeks recognition? The gentleman from California.
Thank you, Mr. Chairman. I speak in support of the amendment. But first I want to talk about both what this committee and what this Congress is doing to the rule of law. Earlier this week, we witnessed the spectacle of the highest-ranking Republican in the country, the Speaker of the House, someone in line for the presidency, standing outside a Manhattan courthouse in a hush-money payment to a porn star trial, vouching for the good moral character of the defendant. Now, I would imagine if you asked a younger Mike Johnson some 10 or 15 years ago, could you ever imagine you would stand outside of a courthouse in a hush-money payment to a porn star trial and vouch for the moral character of the defendant? He would never imagine that possible. But like the proverbial frog in the boiling pot, what we have seen, not just with the Speaker, but with so many of the Republican leadership over the last several years, is one surrender of moral authority after another surrender, one betrayal of what one once stood for, followed by another betrayal, followed by another, until you find yourself standing outside of a Manhattan courthouse, vouching for the moral authority and character of someone who possesses none. And not just losing yourself and losing any sense of right and wrong in the process, but here denigrating the very institution of justice, making the false claims, the patently false claims that this trial in Manhattan was somehow about keeping Donald Trump off the campaign trail, something the Speaker knows is patently false, but willing to repeat. And this is where we are, where our highest-ranking official, Republican official, is essentially telling the American people, don't trust our system of justice. Don't trust the rule of law. And here in this committee, we see something very similar. We see a Republican U.S. attorney brought on to investigate the president. We see him make a report to this Congress that there is nothing prosecutable in what he was able to find. We see him at the same time failing to make a prosecutable case, deciding the next best thing he can do is lob a political grenade in his report and politically belittle the president. And we see this committee unable, after months and months and millions of dollars to make any kind of an impeachable case, decide to follow Mr. Hur's tainted example We can't make a case for any impeachment. There is no high crime. There is no misdemeanor even. And so we will do the next best thing, and we will use this to political advantage by subpoenaing tapes of an interview we already have the transcript for. And why? Because the Republicans in this committee have moved from being the criminal defense firm for the president to being essentially an adjunct of the president's media advertising firm. They want the video for Donald Trump's campaign commercials. That's where this committee has become the Committee on the Judiciary, the committee that is centered or supposed to be centered on the rule of law and on justice. And what are we doing? We're holding the Attorney General of the United States in contempt. And for what? Because he won't give video material for a campaign commercial to this committee on behalf of a president who is a criminal defendant in a hush money payment to a porn star case in New York, the first of many criminal trials that he will face. This is where we are. This is where we are. I first joined this committee, now it's been over 20 years ago. And I suppose like a young Mike Johnson, I could have never imagined this committee would engage in such a thing. It's not as if 20 years ago this committee was some bastion of bipartisan comity. It wasn't. We might and did disagree on abortion and on guns and on the whole host of other policy issues. But I don't think any Democrat or Republican on this committee would have ever imagined it would be brought so low as to hold an attorney general in contempt because it can't get a video for a campaign commercial when it was already given the transcript. But this is where we are. And I think just day after day, moment after moment, year after year, we lose sight of how far we have fallen and any sense of what we are supposed to be about in this committee. And I don't imagine anything I have to say is going to change that, but I do think every now and then the country needs to be reminded that there is nothing okay about this. There's nothing right about this. There's nothing normal about this. We need to get back to demonstrating some devotion to our constituents and the rule of law. And with that, I yield back.
Gentleman yields back. The gentleman from New Jersey is recognized. Will the gentleman yield for a second?
I will yield.
Yeah, I just want to point out we're not seeking the videotape. We're seeking the audio tapes to correct the statement from the gentleman from California. And the Democrats, I believe, held the Attorney General of the United States in contempt a couple Congresses ago when they held Bill Barr in contempt. I yield back to the gentleman from New Jersey.
Thank you, Mr. Chairman. Look, we got to get focused here. The gentleman from California, he's kind of, again, trying to take our eye off the ball. This has nothing to do, this particular issue right here, what we're doing with the courthouse in New York City. This doesn't have anything directly to do with what is going on with President Trump there. And I would be glad to engage in a colloquy or a debate or discussion about how awful what's happening to President Trump is. But that's not the issue here right now. This has nothing to do with the campaign. It has nothing to do with the fact that the speaker did go, as he should have, to support President Trump. But this isn't the issue. It has to do with Special Counsel Hur. And it has to do with what he said. And by the way, he never said it wasn't prosecutable. He decided not to pursue the charges due to the assessment that a jury would find President Biden's age and poor memory as an excuse for mishandling those documents. I didn't say that. Our chairman didn't say that. The special counsel from the Department of Justice said that. The subpoena of the Attorney General is necessary because the Department of Justice has refused to provide the audio recordings of interviews that are crucial for determining the special counsel's assessment of our current president. It's essential for this Congress and the American people to determine whether Special Counsel Hur's assessment is accurate or not. And I'm going to tell you why. And the folks on the other side and the left here are in a bind. Because if our commander-in-chief is so incompetent that he cannot stand trial, he's not fit to stand trial, then he's too incompetent, for God's sake, to be the leader of the most powerful nation on the face of the earth. If President Biden is competent and Special Counsel Hur's assessment was incorrect, then President Biden should face a jury for his crimes of mishandling classified materials. You know, President Trump's facing the full weight of the Department of Justice in his own case on this issue, even though he had the authority to declassify documents because he was the President of the United States when he did it. President Biden, on the other hand, mishandled classified documents, both as a vice president and then as a senator. Guess what? Members of Congress, vice presidents, U.S. senators don't get to take classified documents and remove them from the SCIF. They just don't get to do that. They don't get to declassify documents. He didn't have the authority to declassify. So the audio recordings, why do we want them? Because they're going to reveal whether special counsel Hur's assessment was correct and our president mishandled classified documents, or it will reveal he's incompetent and he's not competent enough to even stand trial and therefore not competent enough to be the President of the United States. That's the choices we have. We've got two choices here. He was competent and he broke the law, or he's incompetent and he's so incompetent, he's such a bumbling old man that he can't even stand trial because they wouldn't really be able to do much with him. That's what we want to find out. That's what we need to know. Either way, it'll be clear our president is unfit to lead, in my opinion, and likely why the DOJ is so damn hesitant to share it. I'll tell you what, anybody else, probably anybody on this committee, if you ask them to share the audio of something we said, believe me, anything I'm saying now you can share anywhere. And you can share anything the chairman says or any of our esteemed members say here on either side. So why don't they want it? They've got a reason, because they're in a bind. And am I willing to set the precedent that subpoenas from Congress and this committee can be ignored? Are you willing to do that? I don't think so. I don't think that we want that to happen. Are we willing to perpetuate, if the president is competent, a two-tier justice system? Again, we see it again, being wielded against one person but not another? The answer to the question should be no. The information requested in this subpoena is crucial. We need the information, not just for uncovering whether our president has acted in a manner deserving of impeachment, but also because the American people deserve to know the answers. We shouldn't be hiding the answers and the truth from the American people. For those reasons, I don't support this amendment, and I do strongly support holding the Attorney General in contempt of Congress. Let it loose. Give us the information. If there's nothing there to worry about, you should have no problem letting us know and letting us see. Let the light in. Let the sunshine in. I yield back.
Gentleman yields back. The gentleman from Maryland is recognized.
Thank you, Mr. Chairman. I want to address a couple of things quickly before I get to the amendment. But one of the arguments I'm hearing from the Republican side over and over again is essentially questioning Mr. Hur's conclusion not to move forward with a prosecution. But I did want to remind my colleagues that under, Mr. Barr, the Department of Justice has taken the position that the committee, referencing this committee, the House Judiciary Committee, has no legitimate role in demanding law enforcement materials with the aim of simply duplicating a criminal inquiry, which is, of course, a function that the Constitution entrusts exclusively to the executive branch. So to the extent you're arguing that you don't agree with his findings and you want to sort of replicate them or go through them again, Mr. Barr argued against that 5 years ago. With respect to the underlying amendment, or the amendment to the ANS, there's a major problem here with moving forward with the language in the amendment, because it's based on the predicate that, and I'll read it, to the date the department has refused to produce the audio recordings despite not having invoked any privilege to justify its failure to comply with the subpoena. And one of the conclusions that it reaches at the end, as a justification for moving forward with contempt, the Attorney General has further invoked no constitutional or legal privilege relieving his obligation to fully respond to the committee's subpoenas.
The gentleman yield.
Sure.
Yeah, we're drafting an amendment. We understand that has to be dealt with in light of the last-minute executive privilege assertion coming from the White House. So we are drafting that amendment, but we are running it past House Counsel. So the majority intends to offer an amendment for the specific language that the gentleman cited.
Will the committee then adopt the ranking member's amendment?
No, we have our own.
Well, I guess we'll have to take a look at it when it gets here. But, moving forward on this basis, even if you amend the language and add that, I want to remind the committee that where there's an assertion of executive privilege, according to Nixon, which is the case that you all have cited, I don't know if you're going to strike that too, but upon receiving a claim of privilege from the chief executive, it became further the duty of the district court to treat the subpoenaed material as presumptively privileged and required the special prosecutor to demonstrate that the presidential material was essential to the justice of the case. And that's because it was a pending criminal case, so moving forward at that point, so there's an expedited process. We obviously don't have an expedited process here, but just to point out and be clear about this, the court said this is presumptively privileged. And so moving forward as if that's not the case, I think is deeply problematic. One of my colleagues over there a minute ago said something about you don't get to choose. But that's exactly what happens when you assert a privilege, especially executive privilege. And the references from the other side with respect to regular civil litigation, which is fine, I engage in regular civil litigation too, but this is litigation between the Article I and Article II branches of the United States. This is constitutional magnitude. So rushing through this quickly, I think, is misguided, and I think it'll lead to, hopefully, a court telling the committee that we're going down the wrong track, we're abusing our power for oversight, especially in the instance where we've got a special counsel that's already been appointed, has reviewed the issues, has come back and stated clearly that there's insufficient evidence in his view to move forward with the prosecution. And I think it's especially problematic, too, if we have to take it to a court again, that there's no evidence here of a refusal to cooperate. In fact, you've got the exact opposite. The above and beyond language in the Barr language and the Barr letter is clearly met here, too. We've got Mr. Garland. He wasn't legally required to release the report, but he did. He wasn't required to release the transcript, but he did. And as was pointed out a minute ago by the ranking member, the department's produced 92,000 pages of documents. We've had, 40 or 50, lawyers from the Department of Justice come and testify, a couple of them in the middle of a criminal prosecution, which is totally unprecedented. So for these reasons and more, I'm urging my colleagues to rethink this approach, because I think ultimately it's going to end up in undermining the ability of this committee to conduct legitimate oversight at the times when that's appropriate. So I've exceeded my time. With that, I yield back, and I thank the chairman.
The gentleman yields back. The gentleman from Alabama is recognized.
Thank you, Mr. Chairman. I yield to Mr. Armstrong.
Thank you. A couple things. One, I would be happy to argue this because and to my colleague from Maryland, I wish you'd have been here in May of 2019, because we legitimately, as the chairman said, we held the Attorney General in contempt after exerting privilege, but it was more than that. We held him in contempt for not violating the law.
Right.
Like, there's actually a statutory requirement that you can't disclose grand jury testimony. So if we talk about the path we're going down and continue in talking about oversight, we don't have to go back to Nixon. We can go to May of 2019. And so to my colleagues on the other side of the aisle that are arguing about this, I would love to get that transcript or audio or video and come back out here. But we're not duplicating a criminal proceeding. There is no criminal proceeding. We got the answer from where we're at. And if you talk about I'd argue this if we go in front of somebody and say, of course they're doing it. They're running out the clock. Like, he could have exerted executive privilege, I don't know, a week ago, a month ago, 6 weeks ago. It's a pattern that is going on with this DOJ and this White House, that as we come up to the precipice of when you're actually going to do something, then they say at the absolute last minute, they drop all of this. And we have a right to do these things. And I fully am aware that the difference between a criminal prosecution and a civil litigation and a congressional hearing are the same thing. But the basic premises of what is the best evidence, what we are entitled to versus what the opposing side says we are entitled to, is something I think the people on my side of the aisle are completely willing to have that conversation with whoever is an independent and neutral arbitrator of those facts.
Will the gentleman yield?
Sure.
You know, the best evidence standard, which I don't think is necessarily applicable here because it's not a court proceeding, and the demeanor evidence things, I think, fell on their face for the same reasons. But the point here, I think, though, is with respect to the 6E issue, it can be waived and routinely is as a matter of practice, and certainly has been for Congress. So, you know, I don't know that that's a real good analogy. But the bottom line here, though, is you guys are arguing you need it for demeanor evidence, which again has no applicability here because it doesn't go to the finding that came from her or the impeachment transcript. And really, this altering the transcript is really what you have to argue. In fact, the chairman argued that. But there's absolutely no evidence of that. In fact, it's a certified transcript. This isn't one that was somebody typed it up on the side. These are the transcripts that we generate on a routine basis in Congress and the Department of Justice.
Reclaiming my time, that's not my, I mean, that might be somebody else's argument. That's not my argument. My argument is if I have the version of going through something and dealing with something and all of those different things, I have watched witnesses in this committee in depositions say things because they know they've agreed to it not being released on video. How something reads and how something sounds is different. That is true. And I'm not arguing that I'm not saying what they're entitled and not entitled to give me. I'm saying I'm entitled to this evidence, and I think this hearing is entitled to it, and I'm willing to have that fight. I have never been in my entire life said, okay, you tell me what I get, and I'll just agree to that. And that's not the point. And regardless of all of the other issues, you don't get to say at the last minute, we're exerting executive privilege because nobody will ever come and voluntarily come into an investigation ever again, because if we release the audio recording instead of the transcript, that's going to have a chilling effect. That is a ridiculous argument. Well, I don't care what the burden of proof is. It's just a ridiculous argument.
Will the gentleman yield again?
Yeah.
I mean, that's an argument that's been raised administration after administration after administration, including by the Trump administration on multiple occasions. The assertion of executive privilege is at least 50 to 60 years old, and that is based on a decision by the executive branch, usually the Department of Justice, to make a decision as to what they'll turn over and what they won't. And if it has to get litigated in court, then the court decides. But this is exactly how it's supposed to go.
Except executive privilege is usually done whether or not you get the information or not. I was here. I remember when the Attorney General came in and said, I can't turn this stuff over because I will be breaking the law. This isn't a matter of whether they're turning it over or not. We already have whatever you think it is. They're saying, we're only going to give you the piece of it we want to give you. We're not going to give you what you guys want. And that's the fundamental disagreement that exists here. We want the evidence of what happened, and the best evidence available is the audio tape. And with that, I yield back.
Gentleman yields back. Gentleman from Alabama yields back. The gentleman from